Good afternoon, everyone. Thank you so much for coming to this PHRC Lunch and Learn session. I'm excited today because we have a very interesting topic that is kind of an enigma to many people. It is reasonable accommodations and emotional support animals. And to give our presentation today, we have PHRC attorneys, Stephanie Chapman and Robert Taylor, who will be leading the discussion. Stephanie and Robert have a wealth of experience in the areas of housing and commercial property, and also investigations and reasonable accommodations in the sphere of public accommodations. So at this time, I will turn the session over to Stephanie Chapman and Robert Taylor, and I will go ahead and pull up our presentation screen.
Good afternoon, everyone. Thank you very much. I'm going to apologize at the beginning and let you know that the presentation was geared toward non-PHRC employees. So with that being said, our first couple of slides are really explaining who we are and what we do. Staff, you know that. So forgive me for the overview, the quick overview on the first slides. The next thing I want to say is Robert and I are open to questions at any time. So please feel free to stop us during the presentation, make comments, ask questions. We really want this to be interactive, so don't hold back. And we can start. So as I told you, the first couple of slides truly are for people that don't know who we are and what we do. But what we're going to talk about is reasonable accommodations and modifications, mainly in housing. So fair housing in Pennsylvania, it's your rights. PHRC, we have a two-part mission, as everyone knows. Again, we can quickly go through it. To enforce our anti-discrimination laws in Pennsylvania and to promote equal opportunity for all. Again, we can go quick. These are the areas in which we have jurisdiction: employment, housing, commercial property, public accommodation, and education. Again, our protected classes, you all know this: race and color, sex, age, only in employment and housing, religion, national origin, ancestry, disability, familial status, which is having children under the age of 18, only in housing, and retaliation. So as you guys know, we're considered substantially equivalent with HUD and the Fair Housing Act. Bear in mind, guys, it doesn't mean we are exactly the same. It means we are substantially equivalent. So some of the differences between HUD's jurisdiction and our jurisdiction is that for HUD to have jurisdiction, there has to be 4 or more properties that the individual owns, or they advertise, or they get federal funds. For a PHRA, you are considered we don't like to say landlord, if you have one other property other than your home. We have jurisdiction over the individual. Of course, our statute of limitations is 180 days. HUD is 365 days. And again, just like EEOC, we dual file all cases that are jurisdictional with HUD. A person can file a complaint if they believe they're discriminated against in housing. Bear in mind, because they have a service animal or a support animal, and it can be the same kind of things: failure to rent, different terms and conditions, failure to accommodate, evict, harass. Now we're getting to the meat of it, guys: the difference between a reasonable modification and a reasonable accommodation. So reasonable modification is a structural change. So it is someone that you need someone to come in and do something for you. A reasonable accommodation is just a change in policies or the rules or practices, or you need some kind of service. So for us, a reasonable failure to make a reasonable accommodation in the rules and policies would be something like not allowing a person with a disability to pay the rent at a different time because the way they get their income. Not allowing someone to have the service animal or an emotional support animal when there's a no pet policy. Refusing to allow a person to modify, right, would be that they need grab bars, they need a ramp, right? Not allowing someone in a construction or in a wheelchair to have the ramp either into their apartment or once they're in their apartment, they need the modification. Now, there are some stipulations that the renters have to agree to restore the interior to the original condition, minus the wear and tear. So if they need a ramp, they need to get rid of the ramp once they're no longer renting there. Please note that if the housing provider receives federal funds, it is the landlord's responsibility to pay for any kind of modification. If they do not, it is the tenant's responsibility to pay for needed modifications. So when we investigate disability complaints, what we need to have, our prima facie case and the things that we need are first, that the complainant has a disability. And again, the disability can be a physical or a mental disability. Does the respondent know that the individual has the disability? Does the complainant need the reasonable accommodation or modification? And does the respondent know that the tenant needs the accommodation or modification? And last but not least is, did the respondent refuse to make the accommodation or modification or a reasonable alternative to the request? If the complainant has presented those prima facie elements, and we know that they're there, then the respondent has to demonstrate that they engaged in the interactive process, right? That there was some kind of back and forth between the individuals. It can show that they offered some kind of alternative that would give the complainant what they need, but not necessarily what they're asking for. So we always have to keep that in mind, right? We have to make sure that that alternative does meet the complainant's needs, though, or that providing that accommodation or modification would be some type of undue hardship for the respondent. Now, bear in mind, guys, undue hardship is a very high standard that respondents have to show. So some of the factors that we look at to think about undue hardship are the extent, the nature, the cost that the modification would require, right? So we have to look at, there might be some different requirements to a mom and pop that only has one rental unit versus a big corporation that has a number of units. There might be some difference in what would be financially able to give to that complainant, right? We also look at things like the extent of the disability or the what they're asking for, right? Because we have to make sure, and this is always in our mind, that the complainant is going to be able to use the housing accommodation, right? So we have to look at exactly what they require. And they also, showing an undue hardship, the respondent can look at the extent in which the modification would demonstrate a threat, a harm, and the same with a reasonable modification or accommodation as well. We get a lot of cases that deal with reasonable modification and accommodation. And as you can tell, one of the reasons is because under housing, disability is our #1 complaint basis. And the last time that we have these statistics, thanks Laura, from 2019 to 2020. And as you can tell, public accommodation and education also have disability as the highest protected class. Employment, it's second. Robert, you're up.
Okay. Thank you, Stephanie.
You're welcome.
So what I'm going to talk about here now is kind of the differences between service and support animals. A lot of times the terms are kind of used interchangeably, but there is a distinct difference between the two of them. In Pennsylvania, the law is generally more liberal than the ADA, the Americans with Disabilities Act, and the Fair Housing Act. The individual's rights vary depending on the area, such as employment, education, housing, public accommodation. The Pennsylvania law does provide the most rights to individuals with service or support animals in the areas of public accommodation and housing. These animals are generally referred to as assistance animals. Now, for a housing provider, it's not a choice as far as whether they can accept an individual's service or support animal, because for the individual, it's a necessity. It's their right for them to have those animals. And under the Pennsylvania Human Relations Act, it is obviously unlawful to discriminate against individuals who use support or service animals for their disability. So the big question that we often see is exactly this: what is the difference? So you can see in this picture here, there's individuals with animals. There's a dog, there's a cat. Obviously, that's a difference, but that's not the difference that we're referring to here. If you look at the picture on the left, that would be an example of a service animal. That dog is providing a service. It is trained to do something for that individual, whereas the other one looks to be much more of a support animal. Now, as I mentioned, with a service animal, that in that picture, that dog was doing a task for that person, and that is generally what a service animal is. It is trained to perform a specific task. A service animal works, provides assistance, or performs tasks to support someone with a disability. And there are numerous examples of them. Just a few that we have there could be pulling a wheelchair, providing mobility support. The most frequently thought of service animal is the seeing eye dog, the dog that guides individuals there with vision impairments. However, there are a lot of dogs that are trained to detect and alert individuals of things such as seizures, or there are dogs that are trained to alert an individual that their blood sugar levels are dropping and that they need to either check their blood sugar or take something to get that blood sugar level back up. An emotional support animal may not have any sort of specific training, but instead does serve a specific function for that individual with the disability. In these cases, that individual benefits emotionally and or physically from having that animal. These are, animals that help to alleviate anxiety, to reduce depression. Anyone that has an animal generally knows that, that they do a very good job of making them feel good. I have a dog right now who is sitting at the door looking at me trying to get in here, and I'm not going to allow that at this point, but if I did, it would want pet and affection. So these animals generally are helping that individual manage that condition that you can't see. That's not obvious. The seeing eye dog with the blind person, you can see that. That's obvious. A person who has anxiety or depression, that's not obvious to look at. It is important, though, to note that in housing, that distinction between a service and a support animal doesn't really matter. The animals can be for physical or emotional support. They do not need to have that special training, and they do not necessarily need to be a dog. It can be a dog, a cat, any type of animal can fit the bill of a support animal. And very importantly, they do not need to be a certain breed or a certain weight class. Additionally, in Pennsylvania, there's no certification or license required. That animal doesn't need to wear a vest or have any special tags. There are a lot of websites out there who will provide individuals with, ESA certification, emotional support animal certification, that they get a certificate, that they might get a vest, they might get a letter. All of these things are unnecessary. It is unfortunately a way for some of these companies to cash in on these types of things and to take advantage of people, but they are not needed. I lost my spot. I'm sorry. So, where we see the bulk of the complaints coming from are, from the housing providers' responses to these requests. So when presented with a request regarding the service or support animal, that housing provider can ask two questions. One, does the person seeking to use and live with the animal have a disability? And the second question being, does that person have a disability-related need for the animal? If the answer to both of these questions is yes, I'm sorry. If the answer to both of those questions is yes, then that request for that animal needs to be granted. Now, a housing provider here can ask for documentation of the need for the animal, but not the tenant's actual disability or medical records. And it's important here also to note that, if a housing provider is asking for that documentation for that need, the documentation does not need to be from the person's primary physician. That letter can come from, a physician, a therapist, psychiatrist, social worker, mental health professional, a nurse practitioner, someone that has that firsthand, that has worked with that person and has that firsthand knowledge of that can verify that need. Now, a housing provider can deny the individual's request if that documentation is not provided in a timely manner. They can also deny that request if the specific animal poses a direct threat to the health and safety of others. This is where you tend to see housing providers say that certain breeds can't be accepted, that they don't want a pit bull or something like that because of the generalization, that thought that those are dangerous animals. For the denial to be based upon that direct threat, it can't be speculative. It has to be something about that specific animal that poses that direct threat to the health and safety of others. It can't be a generalization based on breed or based on the size of the animal. And that can, that's a tricky thing, for a housing provider to prove before the animal is even there. The housing provider can, though, deny the individual's request if that animal would cause substantial damage to the property. But in all situations, before they deny that request, there needs to be an individualized assessment made. Now, once again, housing providers can require that all individuals with animals follow state and local regulations. So they can require that the animal be licensed, that it be current with all of its vaccinations, everything along those lines. They can also issue violations if the animal's conduct violates the rules of the housing provider. So if they're, letting the animal loose, not keeping it on its leash, not taking care of it, they can issue violations based on that. And they can also hold a tenant responsible if the animal causes physical damage to the housing unit. Just because that animal is a service animal or an emotional support animal, it doesn't give it, free range for it to cause damage to the housing unit. Now, it's important to note here that a housing provider cannot charge pet fees or extra security deposits if the person has an assistance animal. These animals are not generally considered pets. So if a housing provider has, if a housing provider generally does allow pets, but charges a fee for an individual to have a pet, that fee needs to be waived for the person who is requesting an emotional support or a service animal, because it is technically not considered a pet. They also, as I mentioned before, they cannot limit the breed or the weight of the assistance animal. They cannot restrict or limit what units or properties individuals with assistance animals can reside in. And they can't restrict or limit where the assistance animals are permitted within the property, except for in a pool. If the property has a pool, they can certainly limit the pet's access to be in the pool. It's important here to remember that this animal is an extension of the person. As I said, it's not a pet. It is providing a service or assistance to that individual, and it is considered an extension of them. Now, in housing and in public accommodations, trainers and handlers of service animals are also covered under the Act. They have the same rights and protections as individuals who utilize their services. It's carved out in the Act that those individuals are specifically mentioned in there as being covered under the Act with the same protections. Stephanie, do you want to talk about the remedies here?
Sure. I'm sorry, there was a question in the chat that I answered. Okay, so housing remedies differ from employment remedies under the Act. This chart that shows some of the remedies available, like we can stop an eviction, we can force them to make the reasonable accommodation or modification. We can make them lease a property to the complainant. We can require policy changes. We can have them reimburse or forgive any kinds of fees that were included. Biggest difference between housing and employment is that we allow money for embarrassment and humiliation. I'm sorry, this says pain. We don't call it pain. It's embarrassment and humiliation damages. So not only out-of-pocket expenses can we get for complainants, but we can also get extra money for them. Any kind of humiliation or embarrassment damages we can get under the housing or under housing. Of course, the same kind of damages that we would get in employment, training. We also are allowed to get civil penalties under in housing. So when we talk about emotional support animals or service animals, we really have to think about it is an extension of that individual. So just like any other thing that a complainant would need based upon their disability, for example, this lady and her cane we wouldn't think twice about asking her, or respondents wouldn't think twice to ask her, do they really need that? Could you give us some medical documentation about your need for that cane? Very rarely do we have respondents when they can see the disability, and it's, for some reason, emotional support animals and service animals really are hard for respondents to fathom that individuals need it, and not just that they want it. But we wouldn't question any other medical device that an individual has. If someone's walking around with oxygen, respondents very rarely go, I really wonder if they need that. Are they just trying to get one by me? Do they need that oxygen? Well, we have to remember that service animals and support animals are the same. The individuals need the service animal. It's really not a choice for them. So again, we wouldn't worry that she's going to be really reckless with her cane, would we? Or that she could scare someone, harm someone, even have damage to the property based upon her cane. Respondents never think of it. We would never think of it, but they don't think twice about these considerations when it's a service or support animal. Pardon me?
There was a question asking about how the civil penalties are calculated.
Well, under the Act, we have amounts that we are allowed to ask for. So for a first violation, Faro, I know you're on here, you can help me out, up to and including, I think, $10,000 or $5,000 for first one.
5,000, Stephanie, but you know what? I'd rather the money go in humiliation and embarrassment to the complainant.
And don't get me wrong, the civil penalty comes to the Commonwealth of Pennsylvania, guys. It doesn't go to the Pennsylvania Human Relations Commission. It goes to the Treasury of the Commonwealth of Pennsylvania. I just think it's another manner in which we do have the ability to emphasize to respondents why it's so important to follow the law. We all get very frustrated in employment that we can't get the kind of damages we would like to get for complainants in employment. We do have more damages that we can ask for in housing. And a civil penalty is just another one to say, you know what, respondent, do the right thing. Don't violate the Pennsylvania Human Relations Act. And this is one of the reasons why. A lot of times before I ask for a civil penalty or the amount of a civil penalty, I really do consider the ability or who the respondent is and the ability of a respondent to pay and their willingness to change their policies, because we all know that that's more important, or at least it's more important to me, that the policies get changed rather than trying to just punish individuals, right? We want them not to do it again. So the civil penalty is just another manner in which, that we have at our disposal in housing cases.
So Stephanie, this is Tamika. I have a question for you, and because I can't see the chat, I just got the entire presentation up, and you may have answered this question. When Robert was talking about there not being a limitation on the size and the breed of the animal, we've been seeing and hearing in the news a lot about some a little bit more, what's the word? I don't even know what elaborate or extravagant support animals, say like a pony or a horse on a plane. And we've been seeing that airlines have been putting restrictions on things like that. So can you talk about that? I know that there are exceptions sometimes with things. So can you kind of just speak to, like you talk about if it's not going to damage the property. Now, you just went into in detail about, well, we shouldn't assume that one of these dogs or cats would mess up the property just like we wouldn't the cane. But when you're talking about something that's a larger animal, we know that equine is really used for emotional support a lot of times. Obviously, you can't have a full-grown, like thoroughbred horse in a 1 or 2 bedroom apartment. So can you just talk a little bit about limitations in terms of those types of things, please?
Sure, and bear in mind, this whole presentation is about a reasonable, underline, quote, bold. It's got to be a reasonable accommodation or modification. It's not just what complainant wants. So Tamika, you're right. let's think about it. I live in a 1-bedroom apartment and I need a horse. I mean, I need the horse. I don't just want a horse. I don't think it would be nice to try and have a horse in my apartment. I really need a horse for a medical reason. Typically, we don't find that they want it in the house. Typically, because it's a horse, those requests would be that they have a horse on their property. So we don't tend to see, and I don't think it's reasonable that a housing provider would be required to allow a complainant to have a horse in their 1-bedroom apartment. Like I wouldn't think it's reasonable to allow them to have chickens in their 1-bedroom apartment. That doesn't mean that they can't, if they rent a property, that they have plenty of space and plenty of room outside for their emotional support chickens or horse. So I don't think we should lose sight of, we always look to see that the request is reasonable. Just because they want it, it would be nice, they're asking, doesn't always put it under a reasonable request. The support animals in airplanes are really a big issue. And let's think that for this presentation, we're speaking mostly about housing and not public accommodation. I mean, we do know that public accommodation can be the hour all by itself, right? Not just housing. So the request would be to have their emotional support animal in a public accommodation, which is an airplane. The airlines used to be pretty lenient about what type of animals they would allow on the airplane, where they would allow it, not in the baggage hold, but be allowed to be on the individual's lap. There'd been a lot of pushback, especially under the last administration, about what types of animals would be allowed. Again, I think that we do have to keep in mind that it has to be reasonable. So do I think it's reasonable that I have to go across country and I need to take my emotional support horse? I don't find that reasonable. I think there are a lot of extenuating circumstances to look at. It's confined small space. Individuals are right next to you. It's crowded. It's not reasonable that a horse fits. There are a lot of things that would make me believe that having your emotional support horse fly with you across the country isn't reasonable. So for me, that's easy. It's an easy determination to me. So I just don't think, and a lot of times that's what respondents say. Oh, are you kidding me? If we allow them to have this, next they're going to want that. We really have to look at it just like they do, on a case-by-case basis. Does the complainant need it? And is it reasonable? So I don't know if I answered your question, Tamika. I hope I did.
You did. You did. And I just thought that would have been a great point to address that, because I know that that's one of the primary questions that comes up. And it's something that we're seeing more and more. And employers, and when I say employers, are I guess people who are offering public accommodation, like the airlines, they're kind of getting to the point where they're bucking that trend. And you talked about the differences between the federal and the state law, and how ours is a little bit more liberal than the federal. And I thought that is an example of a place where it kind of is.
And another place that under the Fair Housing Act, they really do take the view that not anything should be an emotional support animal. We are much more liberal in what we consider an emotional support animal. The Fair Housing Act really considers dogs, and believe it or not, some kind of big lobby this was, miniature ponies or miniature horses as emotional support animals. We've had cases that, have been ferrets and birds and chickens, and we're much more liberal on what we consider an emotional support animal, as far as the type of animal that we consider an emotional support animal, or could be considered an emotional support animal. So that is one big difference again.
I think you can, Steph, sorry, it's Colleen.
Okay, yeah, sure.
I think the airlines, Tamika, when it comes to having the animals on there, you can't exactly at, 30,000 feet ask the passenger to step outside because their animal's out of control versus in a public restaurant or something like that. But I think, when you get the emotional support peacock on the airplane that's flying all over the place, obviously that comes into an issue. And it's frustrating for people that have legitimate service animals that there's so many people just saying that their pet or that, oh, I want to bring my cat or I want to bring my dog along. They haven't been trained in anything other than it makes me feel better. To me, it's a detriment, and that's just my personal opinion. It's a detriment to those that have legit service animals that are performing a specific task. I'm off my soapbox now.
And we know that people, individuals with disabilities are as different as whatever they need. We know that. So it can be hard to understand, but we can't make assumptions. We don't know what an individual may need. We don't know what their disability is because it's not a readily apparent disability. So, respondents really do have to take the time to listen to complainants, to determine what their disability needs are. And you can't just assume that they want their, peacock with them. And we got to get a lot of different requests. We got a lot of different animals, but we still have to make sure that it's reasonable and they go through the same requirements and the same analysis as any other disability case in a reasonable accommodation or a modification.
And I think that's the key thing to take away, is that there needs to be that individualized assessment of every request, that, there's not a blanket, yes or no to any of these types of requests. They need to be assessed individually.
Absolutely. Here's some additional resources available. And then the next one, Tamika, is just our contact information. Look at that, Robert. We didn't even take an hour. Do we have any more questions? This is a really big area. I will tell you that, my housing cases, I don't know if it's because respondents are so recalcitrant, or just because disability is a big area in housing, but we really have a lot of reasonable accommodation cases. They can be tricky. They can be, and they're a little different than regular employment investigations. So I'm surprised we don't have more questions. Maybe we just did such an awesome job, Robert.
Yeah, I certainly think we anticipated there being a lot more questions.
I do have a question. Mary Malloy, hi.
Mm-hmm.
I know, and I sent it in as a chat, but I know certain breeds of dog are considered vicious right off the bat, and they raise your insurance rates in terms of homeowners. Okay.
Mm-hmm.
If a person wants to, like what happened in San Francisco several years ago, the person had 2 enormous Italian attack dogs and they killed someone in the hall. Now, I don't know that, depends on how they're trained, but if you want to keep a vicious breed that's going to raise your insurance rates, can the person be asked to pay that? Can the renter, the disabled person, if the breed that they keep is going to raise your rates, can they be asked to pay the difference?
Well, I think it's an easy question. No, they can't charge more based upon a breed or size of an animal.
Even if it raises their rates, it raises the landlord's, okay.
That I'm telling you from my perspective, because it is a necessity. It is a reasonable accommodation request that the individual needs it based upon their disability. I would tell you, no, they cannot charge more based upon the breed or size of the dog, period.
Okay.
That is my view on this. And yes, I can be very, very staunch about it because, and I am here to tell you no. Now, once something horrid happens and the attacked Italian, whatever it was, killed someone in the hallway, is that individual responsible for whatever their animal did? My answer is absolutely.
Yes.
But just because you own and have that type of breed does not mean something horrible is going to happen. Again, you know, we know that support animals are trained to not be attacking individuals. And so I will tell you that if something happens, and they will be held liable for whatever damage, or just like you would anything else, just like that wheelchair individual runs into every wall and has holes all over their apartment, they're responsible for the damage done in that apartment by their wheelchair. We know that they need that wheelchair, and that's fine. Any damage done, they're responsible for. I feel the same about the emotional support animal or the service animal. Any damage done is the responsibility of the owner of that dog. But just to say, oh, you're in a wheelchair, I know there's going to be damage done to my apartment, don't want you in here. You can't do that to somebody that needs a service animal or support animal either, especially not based upon the breed of the animal. Any pit bull owner will tell you that this ferocious breed really just has a bad reputation. So
Hey, Steph, can I,
Yeah.
could you go a little further with the defense from the respondents of my insurance company doesn't allow these breeds and how we're looking at that? And I just want to say quick before you answer that, I have two very ferocious pit bulls that will lick you until you are dead. So it's not about the breed, it's about the specific animal.
That's right.
They may have studies that some animals are more aggressive or whatever than others, but it's really about that specific animal and their training and their upbringing. I always have to put my pit bull plug in because I have to.
And Heather,
Totally-
I was thinking
totally
about
agree,
you as
Heather.
I was thinking about you when I was talking about it.
That's
But
why I
wasn't
put my
gonna call you
agree.
out.
I have such a ferocious German Shepherd laying here beside me while I'm participating in our lunch and learn. The breed specific legislation, especially with insurance companies, is now being pushed back with some court cases because, again, Stephanie and Heather, and you made your great points. It's the owner, it's not the breed. So they're starting to have some minor cases in court with pushing back, with charging more and insurance and things like that. I'm sorry, Steph, go ahead.
No, that's what this is about. You know, this is a lunch and learn, and I want to learn too.
So we got about 17 more minutes, and there are a couple of questions and there are some clarifications coming through in the chat. So
Okay.
I just want to bring those to your attention so you can elaborate, Stephanie. So I see that legal is weighing in, Stephanie, on your opinion. And we have
Oh,
our
okay.
Deputy Chief Counsel, Morgan Williams. She says that she agrees with Stephanie as well. No raising of the rent unless it would create an undue hardship. And she says that is a defense that needs to be proven. So you can't just out of hand raise up the rent for people who have these different breeds that you are deeming them to be more. So Keith asked another question. He asked about, and I think this is what Heather was getting to. Can you address the issue of housing providers deferring to restrictive pets under their insurance policies? And I believe that Carl came back on, oh no, he has a different question. So I'll go ahead with that. Did Steph, did
Okay,
you
I
address
like
that with
Heather's
Heather?
question too.
Okay.
So I don't know what Heather's, what she's trying to prompt me to say. Let me just tell you that I think that it is also discriminatory for insurance companies to request higher premiums because a dog is, or a certain breed is, you know, residing somewhere. So my my take on this is, I think we should file a complaint against the insurance company that is forcing the landlord or the homeowner provider to pay more or not allow certain breeds. I think it is discrimination. I think it is discriminatory. If the animal is a service animal or a support animal, I do not think that insurance companies should be allowed to raise the rates.
So Somerset raises two questions, and he raises two really good ones. So I want you to pinpoint. He's firing them out quickly.
I bet he
So
has.
he is. So the first one that he asked, did you cover the legislation that involves the abuse of pretending to have a need when there is no reason to support the use of a service or support animal? So that's one, hold space for that. And the second question that Carl asked was, let's see, I'm scrolling because you are adding a lot.
I like his first one better. Let's go back to that.
Let's go back to that one. That's where I'm trying to go.
The need, right? The need, if you also have somebody that has an allergy or something and cannot be around the service animal, right? Wasn't that his question?
That was it. What about allergy? So the scenario is that if you've got another tenant who has an allergy and they say that, well, you're violating my rights to be allergy free by having your pet
it's not
pig
a pet.
or chicken or whatever it is. See, well, that's what they would say, but yeah.
Yeah, but it's
Your
not a
support
pet,
animal,
so
right.
we have to use the right semantics in my lunch and learn.
You're absolutely correct.
A support animal or a service animal. So if somebody is allergic to my support animal or service animal and they go to the respondent and they do the same thing in which I did, saying that they have a disability and this is what they need, right? So they went, the analysis is the same. And Carl, I love it because we don't have my disability is worse than yours and I trump you, right? We don't have that. I don't have that list. It's not in the act. There's no disability worse than another one. A disability is a disability. If somebody requires a reasonable accommodation because there is a service animal near them, respondents required to make a reasonable accommodation for that individual as well. There's no certain number that respondent can only give one accommodation to their tenants. It's as many accommodations are necessary as the requirement under the law for respondents. So perhaps somebody may have to move apartments. Somebody may have to adjust their schedule. Somebody may have to not go to certain areas of the complex. It has to be worked out, and the respondent is required to do both, to accommodate them both. There's no disability worse than another. Would it be a defense that respondent says, I can't have this emotional support animal neighbor to be close to me in the hallway? Sure. So something may have to be done. Respondent may have to move one of you. Doesn't mean either of them don't get the accommodation that they're requesting. It's incumbent upon the respondent to attempt to accommodate both, or however many there may be. Carl,
Perhaps that might look like additional cleaning or something like that in the common areas.
I mean, again, it may be an air purifier. It may be, we don't know. Typically, complainants know more of what's required for their disability and for the situation than we on the outside know. So it's a good place to start in what their request is. But their requirement is that they work with both. Tamika, more questions?
So you
Thank
see,
you,
so now
Stephanie, for
legal,
that excellent
go ahead,
answer, by
Carl.
the way. I
Thank
was
you,
telling
Carl.
Stephanie, thank you for that excellent answer.
So they're raising the questions about the insurance company may be an aider and an abetter.
There you go. That's what I
in
think.
this great
I don't
action.
want to say too much with Carl on the call.
Carl and Morgan both concur. with that.
I want the case too. I want the case.
So here's a question from Liz. Can a landlord claim undue hardship to accommodate the disability and the person who may be allergic at the same time? So could they say, hey, it's an undue hardship, I can't do the extra cleaning, or I can't get the air purifier?
Again, same analysis, right? It is the same analysis for any reasonable accommodation, whether it's an animal or whether it's something else. So the analysis is, they can claim it's an undue hardship. As we know, undue hardship, high bar. Show us it's an undue hardship for you, that you really cannot afford the air purifier, that you can't afford to move somebody, that you can't, I mean, absolutely, these are the defenses that are available to anybody in these types of cases. So sure, it's available to them. I'm hard pressed to believe, though, that having an air purifier is an undue hardship. I mean, that's me, but they can make the claim, just not sure how far it'll go.
So folks are asking, how can they get this information? Attorney Chapman, are you willing to share the presentation?
Absolutely.
Wonderful.
Guys, this is an area that I love. I really enjoy reasonable accommodations. I don't know why, but it's an area I love. Call me. I am always available for questions to back things off of. Keith's team knows that it's just an area I really enjoy. I get it. I know that this is also an area that respondents are very recalcitrant about. As I tell everybody, and I want to give kudos to this group, 9 times out of 10, an individual can tell you what discrimination is. We have done a great job in giving the public the idea of what discrimination is. It is when you treat somebody differently. We have drilled it in their heads. Respondents know it, complainants know it. Now, whether they do it or not is a little, that's a different question, but they know what it is. So I think reasonable accommodation requests for respondents are so difficult because not all, we're telling them that you have to treat this person special, not the same, special. And it really gets respondents upset when we tell them that because of this disability and what they need, that they get it and not everybody does. So I think it is an area that respondents are just recalcitrant to do because it feels wrong. It feels wrong that they get to be treated special, that because I have a no pet policy, they get their support animal. Something doesn't feel right about it. The other tenants are looking at them, wondering why they get this animal when they don't get the animal. I mean, respondents are just very recalcitrant. So, it's incumbent upon us, trainings like these, to let respondents know that because it's a reasonable accommodation or modification request, they have to do more. They have to do extra. And the complainant gets extra if they meet the qualifications necessary. So, in my view, this is why this area is so ripe, why we have so many cases, and why respondents just don't get it right. There, I'm off my soapbox now.
That's good. So Director of Housing Garcia says that reasonable accommodations are an instrument of housing equity. So to your point, Stephanie, that housing equity that a person with a disability might need, that's kind of like having the extra step, the extra booster that you need to help them to have the reasonable enjoyment of their housing property, accommodation. And so that's what it is. And so you may well, as a housing provider, have to go that extra mile for a person with a disability, and that's what the law requires.
Absolutely. And bear in mind, we also have to know that the individual wants it. So there has to be a request. Just because somebody is in a wheelchair doesn't mean respondents or home providers should know what that individual needs. Oh, they're coming in, we have to give them a first floor because they're in a wheelchair. No, maybe that wheelchair user wants to be in the penthouse suite, Well, guess what? Just because they're in a wheelchair does not mean that they need to be on the bottom floor. It's what complaint or what that individual with disability tells them they need. We can't assume what they need, and just like respondents can't assume what they need. So, again, part of the analysis is the individual requested or needs the accommodation. Because that irritates me too, when we look at a complainant and go, oh, they should have had, why didn't they take that first floor? That's, they're in a wheelchair. Doesn't matter. Doesn't matter.
So Attorney Chapman, Deputy Chief asked the question. She says, can you address the misconception that someone, talking about a resident, cheated and brought the animal in first? So now the respondent or housing provider has no duty to accommodate because they brought the person in before they verified and went through the process of saying, I need this reasonable accommodation.
Okay, so that isn't a defense. A valid defense is not, they didn't give me notice prior to them having their support animal or service animal prior to getting it. So that's not a valid defense that they weren't told. As we know, a lot of people that have disabilities that are not readily apparent are not always so gung-ho to disclose their disability, right? And it's just like the service animal or support animal. So until there is a problem, we do find a lot of complainants hadn't asked before. So it's the duty of respondent, once they find out that there is an animal, to engage in that interactive process. Once complainant lets them know that it is due to a disability, that it is a service or support animal, that is when the whole process starts, right? Sorry that I had it here for 2 months prior to telling you, but it isn't a defense to say I don't have to allow them to have it because they had it first. I don't know, Morgan, am I answering the question?
We see that a lot, where they say that, that, hey, they violated the lease by bringing in this pet, and now they want to call it a service animal. But as you're saying, once that housing provider is made aware that this is a disability related need and that accommodation is requested that way, they need to engage in that process. They can't just shut it down and say, no further discussion. You had this animal before you asked for it. Done. So that's
agreed. And again, we have to think about it like any other aid for a disability. I might not rent the apartment and go in and sign my lease with my cane. Doesn't mean I don't need a cane and that I don't use it a lot or sometimes. It is an extension of the individual. So, let's always go back to other medically necessary aids. And just because I didn't tell you I had it doesn't mean I don't need it.
Thank you. So we have a compliment to our interpreter, Julie. Julie from Dr. Margaret Van Assern, she says the interpreter is excellent. So we just want to give you some hands. Kudos to you. You're doing a wonderful job. Thank you. You're adding depth of richness to our presentation. So thank you so much. And Stephanie, I have one last question for you.
Absolutely.
Can you just really clarify for us and elaborate about when a complainant is asked for verification of their disability? So you said that they don't have to provide record of what their disability is, just that they need the accommodation. And it can come from not only their primary physician, but another therapist or something. Can you elaborate on that? Because a lot of times respondents will over ask for what they don't have the legal right to. Can you speak to that, please?
Right. So we know that respondents do not have a right to medical documentation of the specific disability. So they don't have to know what exactly the disability is. All they can know is that they do have a disability and a need for what they're requesting, right? So that, the doctor's note or the therapist's note or, HUD tells us they'll accept the parental note. I haven't gone that far yet, but they tell us that. A note saying this individual has a disability and they need their emotional support animal for a mental disability. I mean, you know, it can be written on a napkin, signed by a doctor, signed by their therapist, and that's enough. I mean, they have no right to a diagnosis, medication, how long they've had it. None of that information respondent is privy to. Is that what you're asking, Tamika?
Yes, yes, that's exactly what I'm asking.
asking. So only that they actually have a disability. And we know under the ADA, you know, since 1990s, that there are many, many things being considered a disability that didn't used to be. As long as it substantially limits a major life activity, is considered a disability. So that they do have a disability and that they need whatever it is they're requesting. So if it's the cat, the chicken, the miniature pony, the peacock, that's enough. And that's all respondent is allowed to have and ask for.
Gotcha. So Lisa Allen asked, what if the complainant is getting the, and she puts in quotes, quote unquote, the letter off of the internet and not from their personal healthcare worker? So she's implying that they're using fake or fraudulent documentation to prove their disability. What about that?
And those things are out there. I think Robert did a good job in the presentation about, you know, they have this vest and they have this special award and certificate saying I'm an emotional support animal that they got offline. So again, we do any other type of investigation and respondents are allowed to do the same thing, that if they have a doctor's note from Tobago that the complainant got in 1985, I think they're allowed to ask for additional information. I would immediately look at that and go, no, he doesn't look like he's from Tobago. He hasn't been to Tobago. It's been a really long time since you've gotten this note that says you need your emotional support peacock. I would say that they are allowed to request additional information. That would not be enough for me. We had the case where the man had a doctor's note from a gynecologist in Washington State. We immediately, just like respondent, looked at the gynecological doctor's note and said, don't know about this. So I do think that they're allowed to ask for current doctor's notes, that it's from the right state. I mean, really the requirement is that the individual that gave them the documentation is familiar with them. So we get a lot of, well, it's my online doctor that is out of state and I talk to them, you know, when I'm feeling down and lonely, perhaps every 3 or 4 months. I don't know how I feel about that. Is that enough to show us that they have a disability and a need for what they're requesting? You know, I think that is something that could be questioned. We do that type of analysis. So I would tell you that if you have some type of note from somebody that is either old, what you consider not a recent note, and when I say recent, I mean, let's be reasonable. I don't think it has to be within the last 6 months, maybe even not the last year. You know, and that it is somebody reputable. We have had respondents tell us, or people call us and say, hey, I went online and this person says for $20, I'll give them a note saying they need the animal. Well, that you know, I think you have a right to ask for additional information. That isn't enough. And I wouldn't be happy with that either.
So we have one last question. This final question, this comes from Liz. More keep coming in. Last question from Liz is, can someone have multiple emotional support animals and service animals? She says, like, i.e. like one per diagnosis. So let's just say if you've got ADHD and you've also got bipolar, do you need a cat? I need a cat and a dog, they're saying. Can you have multiples?
I'm no doctor, since I'm not an MD. If I have some type of documentation that says based upon their disabilities, they need a cat and a dog, I would have to tell you I must be okay with that. I mean, again, I can't put myself in the position of being the medical provider because I'm not. Does it seem reasonable to me And is it reasonable to allow someone to have 2 service animals or support animals? I'm okay with it. I think that when you get up to 50, I think that may not be reasonable. That's not a reasonable accommodation that you have 50 support animals because you have 5 kids and each child has 10 disabilities. And, we're back to the reasonableness standard. Do I think that if you have multiple diagnoses, you need multiple service animals? Yeah, 2 I think is reasonable. If I live in a, 50-acre home, then it's reasonable that I have more than 2. If I live in a 1-bedroom apartment, maybe 2 could be the most reasonable we could expect. So we can't lose our mind and not remember the reasonableness standard. But basically, my answer to you, Liz, is if they have the medical documentation required, 2, I'm good with.
That brings to mind sanitation then issues. So sometimes local boroughs or townships or whatever, the ordinance, they might have some type of sanitation concerns regarding animals. So would the complainant be responsible for keeping up with all standards of cleanliness and sanitation in that housing opportunity?
Absolutely. And maybe in certain circumstances, these local codes and township and local municipality rules may trump us depending on what the request is, right? So, to want an elephant and a tiger in the city of Harrisburg, that may not be okay. We may not be able to say, oh yeah, those emotional support elephants and tigers, you're allowed to have in your apartment complex in downtown Harrisburg. Again, I think we have to go back to that reasonableness. So I'm not saying that some local ordinances and municipality requirements may not trump. It really depends what it is. Don't give me Florida, Palm Beach, that you can't have a dog over, 5 pounds because our borough doesn't want, dogs over 5 pounds. I don't think that's reasonable. Or you don't want pit bulls, or you don't want really mean German shepherds. Those aren't reasonable types of ordinances. So those breed restriction and weight restrictions aren't. But, the elephant in Harrisburg might be reasonable, guys, that you can't have that. So we have to look at it on a case-by-case basis, all of the circumstances, before we would say you could have it or not.
Gotcha. All right. Thank you so much to our housing experts, Attorney Stephanie Chapman and Attorney Robert Taylor. You've done a wonderful job of really breaking down this issue that even for those of us who are practitioners, we always have questions about. So thank you. Thank you so much. I'm going to defer to Housing Director Adrian Garcia. Do you have any comments that you would like to make, Adrian, before we get off of here? Adrian, go on.